Good evening, ladies and gentlemen, and welcome to the monthly Montgomery County Libertarian Party Liberty Forum. It's good to be here. My name is Ken Krawchuk. I am the past chair of the Libertarian Party of Pennsylvania, and Libertarian Party of Montgomery County, and Abington Township, and a whole bunch of other things. And I'm also the host of the Pennsylvania Project radio show on WWDB in Philadelphia. We are here with our monthly Liberty Forum, where we bring in a parade of liberty-minded speakers to talk about liberty-minded things. And this month we got a goodie. This is one of my favorite subjects, and I'm glad we got this one tonight. Not only that, we got a great guy to do it. Our guest today is Rob Cowburn. He is the chair of the Libertarian Party of Pennsylvania. He's also an attorney from Pittsburgh. He drove all the way out here to Montgomery County to be here tonight. Definitely, we appreciate that. He's also a grad student at the Mises Institute. Let's hope he graduates from there, becomes better. And he's a Toastmaster. Doesn't get better than that. The topic of his speech tonight will be jury nullification. That's where jurors have the right to try not only the facts of a case, but also the law. Somebody can be guilty as hell, but the jury still can find them not guilty if they find the law is bad. That's enough of me. Now, those of you who are online, I'll be watching. If you have any questions, feel free to post them, and we'll pass them on to Rob. But for right now, let me get out of the way and introduce our speaker tonight for jury nullification, Rob Cowburn. You're welcome.
Thank you, Montgomery County Libertarians, for having me. This is a topic very close to me, and if you know me, you may have heard me mention it once or twice before. So the topic is jury nullification. I guess probably a good place to start is, what are the topics that we're really getting into here? Well, it's the trial by jury, the habeas corpus, the right to be confront your accusers. Some groundwork in our system here. The way that this works is, if you're accused of a crime, you have the presumption of innocence, the right to presumption of innocence. You have to be proven guilty by a court on probable cause, and here we use the jury of your peers as the adjudicators of fact. So in the law, there are two main things that happen when you're going to trial. You have the trier of law and the trier of fact. Now, traditionally, the way it works in the American system is that the judge is a trier of law. They decide issues of what the law means, what the law says, and how to apply the law. And the jury is responsible for being the trier of fact. Now, the trier of fact decides, they hear all the evidence, they decide which facts from which side to accept, what actually happened. And then the judge takes the facts given by the jury and applies the law, and then based on that, a person can be convicted of a crime. This is actually, our American system is pretty special, because there's not many places where we use a jury or even the sides that present their own evidence. In most other jurisdictions, the way it happens is an independent investigation by the judge or by the court. They'll go out, they'll find the facts, and then they'll bring it to the jury, and then they can decide if a crime occurred. But here we have the parties bring the facts, all right, and then the jury decides which ones to believe. They give that to the judge. The judge says if a crime occurred or not. That's the common understanding of how a trial in the American system works. Now, jury nullification is the concept that the jury is not just the trier of the facts, but they're also the trier of law. Now, what this means is that the jury can say, even if a person has satisfied all of the elements that a law says is a crime, if they feel that it is not a just law or a just outcome, they can refuse to convict a person. So they can nullify a bad law or an unjust law without having to have the law overturned. The jury can just say, we're going to refuse to convict, even though the law says this is a crime, we're not going to do it. And it's an unbelievably powerful tool of the people to have a check on government. One of my favorite legal philosophers, Lysander Spooner, you may have heard of him if you're in the libertarian world. The way that he described it, I think is rather on point. So Spooner said, there has been no clearer principle of English or American constitutional law than that in the criminal case, it is not only the right and duty of juries to judge what are the facts, but what is the law and what was the moral intent of the accused, but that is also their right and their primary and paramount duty to judge the justice of the law and hold all laws invalid that are, in their opinion, unjust or oppressive, and all persons guiltless in violating or resisting the execution of such laws. In the United States, this really came into prominence during the Prohibition era, particularly with the Fugitive Slave Act. If you're not familiar, the Fugitive Slave Act was federal law that required runaway slaves to be returned to their owners if they were found, to have run away, and even if they got to a different state, they were required to be returned. The juries in the northern state started applying this quite heavily in refusing to return runaway slaves to their owners before we had the end of slavery. It has been recognized in the United States as a right. So jury nullification is a right that all jurors have to be able to decide if a law is just and if under the facts that they have determined, if they want to convict or not. It's been an interesting path, and actually here in Pennsylvania, we have a special connection to jury nullification. The first traditionally recognized instance of jury nullification happening was actually, it was in Britain, but it involved a case with William Penn. William Penn was accused of unlawful assembly. He would be holding mass in the streets because at the time the British rule was that you couldn't have mass in an unsanctioned church or an unsanctioned location. And that had a lot to do with Reformation and the breakaway from the Catholic Church. But William Penn, a very well admired and respected person at the time in Britain, was holding his own unsanctioned masses basically in the streets. And he was brought before the court where they were charging him with unlawful assembly. Now, in that case, the jury actually came back. They said, yes, he is guilty of what happened, but they refused to apply the punishment that the law required. The judge in that case was so upset that the jury, for not coming back with the required verdict, that he actually sent them back and ordered them to come back with the correct verdict. The second time they came back, again, they refused to convict him. And what the judge did is actually he locked the entire jury up in the Tower of London and charged them all with contempt. Now, the case that actually sets the law is called Bushell's case because it wasn't the William Penn case. It was the case against the jury who refused to convict him. The judge charged them all with, and they were prosecuted with contempt for refusing a court order, and it went up on appeal, and the backlash was so heavy from the people, and that the Crown actually acknowledged that the jury could not be compelled to be forced to come back with a verdict. They couldn't be charged for what they did in their verdict, and that was a creation of jury nullification. William Penn actually cites this as one of his main reasons for immigrating to the United States, and eventually go on to settle in what would become Pennsylvania. So, I think we here in Pennsylvania have a very special and unique relationship with jury nullification, and the importance of that I'll get into a bit later. But so, what was the first instance here in the United States? Well, I think it goes to show kind of the spirit of the original mentality of the founders in the country at the time. The first recognized instance of jury nullification in the United States was during the War of 1812. There was Marlborough, Maryland. What happened there was, the War of 1812, the British came back over, tried to start the conflict again. And they actually had taken hostage a couple of members of the town of Marlborough. In response, the militia formed in Marlborough and captured a couple of the townspeople themselves. So we had, I think, four of the townspeople had been captured, and then the militia captured 6 of the military redcoats from one of the regiments of the British. And the mayor actually of Marlborough at the time, by the name of John Hodges, he took it on his own. He went unarmed up to the British regiment and offered to say, hey, why don't we swap? We'll give you back our the military guys that we had taken, and you exchange for the townspeople. And they agreed, and this was widely seen as a heroic event that happened. They had a big parade. John Hodges was the guest of honor, had a big speech, and I think shortly after the War of 1812 ended. But what happened during the parade, while he's being honored for this heroic act of exchanging the prisoners for the townspeople, as soon as he was finished, he was walked off the stage, and he was immediately encountered by 2 guys, and they were federal agents, and one of them handed him a piece of paper, and the other one put handcuffs on him. And he was arrested for treason, for providing aid and comfort to a foreign enemy, for returning the troops to the British. Now, an interesting fact about this: when he was at his trial, the federal judge who was prosecuting the case was actually the same person who introduced him for his speech during the parade that they held for him, where he was the guest of honor. And the prosecutor, the federal prosecutor, was there. The whole town was kind of a part of the parade, and now they were also prosecuting him. And what happened? That was the jury there said, we see the facts. Yes, he's guilty of all the things he said, but we're refusing to prosecute him. And that was the first time that jury nullification was really exercised here in the United States. And it's been recognized as a right by the Supreme Court. The jury has the right to judge the justice of the law. They have the right to decide if some words on a paper written by government officials is just and should be applied to somebody accused of it. And it's the implications of it, particularly I think today, where we have so much overreach with the war on drugs, with Second Amendment violations. If a community really understood this, they could end the war on drugs in their community pretty much overnight by just refusing to convict somebody again of a non-violent drug offense. So the implications of jury the implications of jury nullification are huge, and the power is so important that we remember that. Now, how has it been treated in the courts, and how has it developed over the years to where we have what it is today? Well, almost immediately, you can see why the state wouldn't really want people deciding if the laws that they've created are good enough to stand the test of justice. So the courts have been rather unfavorable in the treatment of jury nullification. I think starting in 1895, Sparf v. U.S. The Supreme Court held there that the judge has no responsibility to inform the jury of their right to nullification. Now, what does that exactly mean? So, when you're in a jury trial, both sides will plead their case, and at the end, before the jury goes into deliberation, the judge will issue a number of instructions. The judge can decide which instructions they want to give. Usually, they'll instruct the people of the jury on the elements of the crime. They'll instruct them on certain issues of law that have come up, and then either side is able to suggest what other instructions they'd like to have. And what this case did, Sparf, is it told the court that they do not have to allow a request from either side, but usually from the defense, that a jury has this right to nullification. So if the defense wants to inform the jury, hey, if you don't believe this law is just, you have the recognized right to choose not to convict, even if you find them guilty of all of the elements that the law says is a crime. So that's the start of how they kind of got to silence the effect and the knowledge of jury nullification. It progressed on from there. In 1969, the Fourth Circuit this was great. They upheld the right that jury nullification exists, but at the same time refused to permit an instruction to the jury of their right to nullification. So they're recognizing, yes, this right exists, but you don't get to tell the jury about it. 1972. I'm sorry, 1988, Sixth Circuit, Sixth Circuit Court of Appeals held that the jury, there is no such thing as a jury nullification. 1997, Second Circuit court ruled that the jury can be removed if there is evidence that a jury intends to nullify the law. So they took the additional step now that even if you're on the jury and you're in deliberation, which is supposed to be one of the most sanctioned places where the jury is free to discuss anything that they would like with each other, if you want to inform your other jurors of the right to nullification, you can actually be removed from the panel and replaced. So the courts have gone a long way to try and silence the ability to even know about your right to nullification. And I think this is the biggest danger we've faced, particularly with the war on drugs, with the criminalization of nonviolent offenses, with the continuing Second Amendment violations and criminalization of right to carry, and jury nullification is kind of one of the last places that the people can have a real say on how how and if these clearly unconstitutional, in my opinion, laws can be applied. You're not allowed to instruct the jury. You're not allowed to, and the jury can't instruct each other. And in fact, there've been cases where the people, even outside of the court, if they try and instruct a juror, they can be held in contempt. So with all of that, where do we go from here? How do we even inform people that they have this right to refuse to convict someone of a crime that they think is unjust? Well, I think the path forward here is really at the state level. Crimes were always meant to be dealt with at the state. We unfortunately have turned a lot of things over at the federal level. We have so many more federal crimes and mandatory laws being impressed on the states, like the drinking age. You won't get your highway fund back if you don't make the drinking age a crime at the age of 21. So we have a huge amount of influence from the federal government, but really crimes are always meant to be dealt with at the state level. I don't think there's much hope of getting a law change at the federal level in this direction anyway. So how do we secure the right of nullification? How do we inform people that it exists? Well, to me, it would seem that the path forward here is a constitutional amendment at the state level that would require a jury in a criminal case be informed of their right to nullification at every criminal trial. I think really that's the only way that you can secure it. And the reason I say that is there've been a couple attempts at putting jury nullification into law. One of the closest I think we got was in New Hampshire in 2012. They actually passed a state law allowing defendants to request an instruction of jury nullification at criminal trials. But in 2014, the New Hampshire Supreme Court actually overturned that law and said the way the statute was written actually didn't require the judge to give instruction on jury nullification specifically. So it seems like the path forward is going to be state constitutional amendments requiring jury nullification be mandatory instruction at every criminal trial. Here again in Pennsylvania, we are uniquely connected to jury nullification. There've been a couple of states have tried this already. North Dakota being one in 2002. They unsuccessfully were able to pass a referendum to amend it. But with the connection of Pennsylvania to jury nullification itself, through William Penn, and with the PA Constitution, which it in itself it actually does recognize partially a piece of jury nullification. If we can't get it done here, I think that we're in trouble trying to do it anywhere else. So it's on us here in Pennsylvania to push forward this idea and this very crucial tool of the people to have a check and oversight on their government without needing permission, without needing to change any laws. I think we're uniquely seated here to try and do that. Unfortunately, in Pennsylvania, there is no way to get a ballot measure, a referendum on the ballots through petitioning. We actually have to have a state legislature bring a bill to get the referendum on. But I think this is where libertarians have a unique opportunity. Every 2 years we run state candidates, and these state candidates, a great way to gain some attention and gain some exposure about jury nullification would be to run on the issue that they'll introduce a ballot measure to require jury nullification as a mandatory instruction at every criminal trial. It's one of the most powerful and I think hopeful tools that we have. We're uniquely positioned here in Pennsylvania to push it forward, and at the very least, I think just spreading the knowledge of its existence, through running campaigns based on introducing it as a ballot measure, even if they don't ever actually get elected or are successful at introducing it. You know, just the informing the people of the right and speaking about it every chance that we get. You know, maybe a couple of those people end up on a jury and be able to apply it as it was intended. So that is jury nullification, what it is, what our connection here in Pennsylvania, and you know, where we go from here to try and secure that right and make sure that we are able to have those necessary checks in a world that seems to continue to eat away at the Constitution and wanting more and more to criminalize you know, behavior. So thank you, and open it up for any questions. Yes.
So, thank you for coming out tonight, Rob, and talking about jury nullification. You mentioned that judges and DAs, they don't have to give instructions on jury nullification. So, even though it's legal,
Not only is it legal, it's a right.
it's a right. Even though you have a right to jury nullification, the law, the system will
Right.
not instruct jurors about that right.
Right.
So, how does that fit into having a fair trial or due process or a trial by your peers?
Well, our right to habeas corpus, if it still exists, it's on its deathbed at the moment. We've got so many obstacles in actually getting to trial in the first place, but those are probably talks for another day. You know, with the courts flooded with all of the small level drug offenses, they're pushing people through mandatory minimums, overcharging, getting people scared to even get to trial in the first place. There's so many obstacles to actually, you know, having even getting to have your day in court. The case history is in a way it was very clever. Some very intelligent attorneys were able to basically prohibit it from being talked about while also recognizing that, oh, it exists. It exists. You can't say it. You can't tell anybody about it. You can't be informed about it, but it does exist. So you can do it, but you can't ever talk about it or know about it or try and learn about it. I don't know how that represents a fair trial. Again, I think if there was more awareness of the fact that it exists in the first place, the attempts to overturn it would not be too popular, or the attempts to mask it and hide it wouldn't be as popular as, or be allowed to stand the way that it has. But I mean, there's a number of issues that like that. Qualified immunity is one that I think people knew more about. They wouldn't tolerate it, but how do you confront the thing that you're not allowed to talk about? It's an interesting legal fiction, question of legal fiction that I'm not so sure. There's a good answer. Yeah. Oh.
I'm not sure how it works in other counties in this state, but in Montgomery County, well, I should preface this by saying I think I've been asked to. I got the notice to serve on a jury about 3 or 4 times. I've never even gotten to the courthouse, and I think this is the reason why. In Montgomery County, they send you the notice, and then you have the option, I guess, of going online, which I always do. And they ask you to fill out a questionnaire, and you give them your information. But at the very end of it, there's a question. Is there anything else we need to know about you? And every time I've answered, I am a supporter and a believer in the concept of jury nullification.
Yep.
And then the next morning, I go back online to see what my status is, and I don't even have to go. So I'm not necessarily sure this is a good tactic to help spread the word, but I'm thinking to myself, if more people, at least in this county, knew that's an answer that they should give, it seems to me it would really shrink the jury pool,
Yeah.
the potential jury pool.
Yeah.
But the reason I bring it up, and I'm just sort of asking, what's your opinion of, because some people have taken me to task. They said, no, you shouldn't say that. You should be on the jury if you know about this.
Yeah.
But I look at it like, I think everyone should do what I'm doing.
Well, so it's a fantastic point that you brought up, and that's the danger of the way that the case law has developed. So I think it was U.S. v. Moylan, 1969 Fourth Circuit Court of Appeals. The court may refuse to permit an instruction to the jury of their right. 97 Second Circuit, a juror can be removed if there is evidence that a jury intends to nullify. So this gave precedent that was citable. If you're not in the Second Circuit, it's only non-binding precedent, but it's been used to be a justification to during the voir dire process of choosing jurors to keep jurors out. The court and the prosecution does not want the jury taking the law into their own hands. They didn't go to law school. They haven't practiced this forever. They weren't elected to be a judge. They weren't appointed. They don't. You, the people, don't have the sophistication to be judging the law. So it is a absolutely justifiable excuse to excuse a juror if they indicate that they support or would use jury nullification.
But what if I keep my mouth shut instead, and I get on the jury, and we go through the trial, I still don't say a damn thing. Nobody knows that I know this, and then we go into our deliberations, and I go, guys, you know what we can do here, don't you?
Yeah, you're absolutely right. And in Pennsylvania, that has not been.
No one's going to know this outside of the judge is going to know it. Until we go out or until someone rats on it.
Well, that's true, but do not underestimate the willingness of your fellow jurors.
Oh no, I definitely will.
Fortunately, you need a unanimous.
Yes.
Unanimous return of all 12 jurors to convict. So I would suggest if I were picked to be on a criminal jury, what you do is knowing that you can be excluded just for suggesting that you are aware of jury nullification. I would bide my time. I would use my knowledge to determine if it was the right circumstance to apply it, and if it was, I would choose to exercise my right to nullify. And then after the fact, if a lot of times jurors can be a favorite of media sources to go to. I would then use that opportunity to say, well, what I did was I used my power of jury nullification to refuse to convict because of this unjust law. So if I were to tactfully say, how can you as a juror apply and spread the awareness of jury nullification, it would be to use it and then after the fact tell everybody exactly what you did. Because after the fact, you have absolute immunity for what you've done, and double jeopardy will still apply. They can't call a mistrial for that. So that would be my recommendation as a juror. But really, what we want, right, is to let juries know of this right before they ever go in to deliberate, and not hear about it after the fact from one person who learned about it somewhere along the way. And that's why. With all of the roadblocks and barriers that the courts have put into place to allow even just the hinting of its existence to be a reason for a mistrial or excusing a juror, I don't see another way besides a state constitutional amendment requiring it as a mandatory instruction. Now, intelligent prosecutors and judges will always find a way around the words of the law. I think that's quite obvious in the condition that the judicial system, but the law is kind of in general today. But if you put it in the Constitution, at least until they outright declare that the Constitution is invalid and we're not going to use it anymore, then it at least is in there, and hopefully, I don't know yet of the clever argument that a prosecutor would use to get around that. I'm sure it'll come, but I think that's really the only opportunity we have to create awareness before the trial. But if you don't want to be picked for a jury, a great way to do that is to put on that application that you support or believe or even know about jury nullification.
Yeah, let's get out of jury.
Yeah.
Rob, you mentioned amending the Constitution. Which section would you do? Article 1, Section 5? What would be the wording?
Well,
Put you on the spot here.
Just to clarify, is that US Constitution?
no,
Okay.
so
Okay.
State.
Yeah, the Pennsylvania
That's
state.
Pennsylvania guy.
Yeah, the Pennsylvania State Constitution. The wording, the wording I think is quite simple. Let's see.
What article are you?
Well, Article 1, Section 5 is the trial by jury.
Yeah, Article 1, Section 5. It shall be required at every criminal trial that the jury be instructed of their right to judge the law as well as the fact. And that, I think that would be about as comprehensive as you could get it.
Okay. You know, I'll send that back to you. I got it written here.
Excellent.
You polish the wording.
Yeah. Yeah, Mike.
So, you talked about how the state didn't trust the people
Yeah.
as far as being jurors go, and that there's no instructions for jury nullification by the judge or the DA.
Well, so right now, there's nowhere that like, outright prohibits it, but the case law has said that there is no right to it, to say it, and it has developed into there's no right to even talk about it at all. So
And if you do,
a
as
judge
a
could
juror-
allow it if they wanted to. There's nowhere where they prohibit an instruction yet. But the discretion is up to the judge, and unless you've got a liberty-minded constitutional judge, you're going to have difficulty running into that.
And that goes as far as the instruction, but as a juror, if you even discuss it, you can be removed.
Yes, yep, that's the way that the case law has been.
And again, I gotta ask, how does that fit into having a fair trial? Or a trial by your peers? If so, in other words, let me ask it this way. If you are a judge or a DA and you run into an incredible unlucky bout of every jury for that particular case, you run into one person that at least supports jury nullification, you're just gonna keep bouncing people off a jury until you get your jury pool?
Yes.
How is
yeah.
that not, because that's a question for different talk, I think, but.
I always like to look to people wiser and smarter than myself who have said it better in the past. And I find myself returning to Lansdale Spooner so many times.
Right.
But in his work, Trial by Jury, 1852, I think he encapsulated why you can't have a fair trial without this right and without the knowledge of it. He said, so if the government may dictate to the jury what laws they are to enforce, it is no longer a trial by the country, but a trial by the government, because the jury then try the accused not by any standard of their own, not by their own judgment of judgments of their rightful liberties, but by a standard dictated to them by the government. And the standards thus dictated by the government become the measure of people's liberty. If the government dictates the standard of trial, it of course dictates the result of the trial. And such a trial is no trial by country, it's a trial by government. And the government determines what are its own powers over the people, instead of the people determining what their own liberties are against the government. I think that sums up your point pretty well. We're either a people of the people, or we're a people of the government. Which one do we want to be? Fortunately, I think that we still have some ability to solidify government by the people first, rather than the pure state dictating to us what our rights are. steadily moving away from that, it would seem, but I think we still do have the opportunity here to save that a bit longer. So I don't know how you have a fair, a just trial without the ability to judge also the law. There's a lot of talk in libertarian circles about the efficacy and even benefit at all of democracy, and that's a talk for another day. But if in a pure democracy, if people wanted to vote slavery back in, and we just more than half of us voted that, and we didn't have the right to jury nullification, then slavery is back, and there's no ability to oppose that. With things like jury nullification, they can make any law that they want, but as long as the people have an understanding of what justice was meant to be and what the role of government ought to be, I think it is a term I like to use, what the government ought to be dictating or making laws about. If we don't have that ability, then I think that we're all we're back to a time before the American form of government.
Go ahead, Randy.
Yes.
Can somebody?
Rob, when you made your suggestion for the constitutional amendment, why did you limit it to criminal trials? Why not any trial?
That's a fantastic point. I think, unfortunately, we are in a position of having to choose our battles. There is less favor, even among liberty circles, for allowing nullification in a civil sense. I think that it would be a great thing to solidify as well. But when we're talking about the caging of human beings for non-violent, in my opinion, non-criminal acts, to start there would be a gateway toward leading there. In a perfect world, I would agree with you that it should be at every trial that the jury has the right to declare if a law is just. There are just as many civil penalties that are unconstitutional, if you want to say it like that, or unjust, or against a free people and against individual liberty. But maybe it's my personal experience in the criminal world. I may focus on that more often than not. But I think that it would be a more accepted view, particularly within inner city, urban communities, with the things like the war on drugs, to get this as the doorway back towards the mindset of community, local, individual control of government and a government of the people, rather than if we try to do it all at once. I don't know if there'd be more compelling and still unjust arguments against why we should include that as an amendment. So I think focusing on the criminal aspect specifically at first, with considering the overwhelming support of, against the war on drugs, ending it. I think that is probably the best doorway into getting nullification talked about and codified in a meaningful sense.
Okay. I guess I'd sooner go for all trials than just criminal. But
Yeah, I think it would be much more difficult to go for all trials than it would be to start with criminal, and hopefully once the public has a mind and taste for liberty again, then you can move all the way back to there. The right still exists, but to codify it, I think would take a more step-by-step approach.
okay, thank you.
How does the county decide who gets a notice to serve? Because it always seems like a big mystery. Everyone says, oh, it comes from the voting rolls. No, it comes from something else. Where do they get the names? How do they,
So I believe in Pennsylvania here, that's still left up to local county rules to decide how they're going to do their selection. There are some oversights at the state level, but I think most of them are local.
Is it
rules.
local? Because like my follow-up to that would be, since this is such a natural issue for libertarians, does anyone have an idea of like how many libertarians have served on a jury in the past year?
That'd be an interesting stat.
Well, I think an even better question is how many people at all have served on a jury in the past year, because jury trials are very rare. And I'll tell you this, the biggest expense in litigation on a national level is actually in jury selection. There's more money spent in jury selection preparation than any other part of litigation. And in running mock juries and running all sorts of demographic research projects, more money spent by the big cases on jury selection than anywhere else. So I tell you, it's not something that is walked into lightly by anybody, you know, on any side once you're actually at trial. Going to trial, going to criminal trial in this day is already, your back is up against the wall with minimum mandatory sentencing, overcharging, qualified immunity, prosecutorial immunity. They make it so such a risk to even try to go to trial in the first place, so rarely. But I would say how many people are even going to juries at all.
You know, I have that statistic. A couple months ago, we had Rob Lankin here for our Liberty Forum. He's a criminal prison expert.
Yeah.
And he said that over 90% of convictions never go to court.
Yeah, that's
Over
right.
90%.
That's right. That's right.
So Montgomery County, in my day, so I'm no stranger to the judicial system or the penal system. And in my day, Montgomery County, Pennsylvania, the county was a 96% conviction rate on 98% plea bargains alone.
Yeah, right.
Yeah.
And hearing you say about no instructions for jury nullification makes me wonder if that is a big reason why nobody knows about this, or that you can be removed as a juror, or any of the other things that you had said about jury nullification.
Well,
And I can't imagine, I'm sorry, and that was back in 1998, and I can't imagine that number has changed much in the 25 years.
Two big things happened. Minimum mandatory sentencing, I think, was probably the biggest. Probably minimum mandatory sentencing is. Oh, and the war on drugs, the criminalization of nonviolent offenses, and matched with minimum mandatory sentencing, has flooded the courts with low-level offenses that the potential punishment is absolutely astronomical. You know, we're all familiar with the cases where a gram of crack in the 90s could have got you 25 years to life. There are multiple people serving life sentences on the 3 strikes rule in different states just for possession charges alone. The courts wanted, I think the entire mentality of those who were in support of the war on drugs wanted to say, we're going to come at you with everything we have to combat an issue that I don't think that there is any solution for, and I don't think that law can resolve. But they've thrown everything and the kitchen sink at it to make it so risky to just try and have your day in court in the first place, just to get you to plead out. They arrest you, overcharge you, threaten you with decades in jail, and you take a plea bargain out because they'll offer you no time at all.
A lot of probation time on top of it.
Right. And then if you ever get caught again, now they've got you.
It's a revolving door, that one.
Right. The recidivism and the deliberate attempt to have recidivism, I think, is a real problem. But I don't think you really get to have your day in court in the first place anymore.
Go ahead.
So has there been any recent cases that jury nullification has actually been used?
I think that people do it actually quite often without even knowing. If you get one juror on a criminal trial who says, I'm not convicting this person of this, maybe it's if you're in a area that is big on Second Amendment rights, and you've got one juror or maybe multiple who just refuse to believe that carrying a weapon on its own is a crime, and they just refuse to do it. Well, that person is just done jury nullification.
Kyle Rittenhouse fall under that?
The Rittenhouse case is that's quite a topic, but I think that it was so clear by the evidence that was there that he was actually the victim and not the aggressor there, that I think that's what happened there. I think that was just a acquittal on the facts alone and not nullification. Someone in an urban community who just will not convict a young person for a non-violent drug offense, that person is just nullified. So I think it happens a lot without people even knowing that they're doing it. Because we have this, I think, compulsion, towards justice, and why a jury of our peers is such an important part of a free people and a free society. We just inherently, will not do things that we know are unjust. Yep.
So it sounds like there's a long history of jury nullification for Pennsylvania, starting with William Penn, and all throughout colonial and the early Pennsylvania state, all the way through, I think the 80s was the last case you cited or so.
Yeah, some of those were in other areas, but Pennsylvania is like intimately. I don't think we would be called Pennsylvania without jury nullification, without William Penn being wrongfully, attempted to be convicted, and those people just refused to do it. I don't think we would be called Pennsylvania because he may never have immigrated here.
So would it be fair to say that there's plenty of precedent in Pennsylvania state law to help get a constitutional amendment passed? I mean, it sounds like other than education and constitutional amendment, the people are never going to know.
There's plenty of precedent in Pennsylvania that the right here exists, but there is no precedent to get a constitutional amendment passed because it's never been attempted. Really, I think if people understood our rich and intimate history with nullification, that we have a really unique chance and opportunity here to maybe see it through and have it passed. I'm optimistic ever since the last referendum during the COVID mandates that the people chose. We will decide. I think that is a great indication of the mind of people in Pennsylvania that this is something that they would hear if we could just get it brought. If we could have just a legislature bring it and say we're going to get this introduced. Unless we can amend the Constitution and get a path for ballot referendums through petition, I don't know. We're going to have a good legislature trying to introduce that.
This would be a good time to bring up, I don't know if you're aware of it, it must be the Fully Informed Jury Association.
Yeah.
If you go to fija.org, they've got a lot of information on this, and they also have a Facebook page, which I've been following for years. So they're another national advocate for this concept.
Excellent, thank you.
Sure.
Yeah, Rob, something you said early on about getting the constitutional change on the ballot. You said that there's no way to do it. When I was first playing around with ChatGPT, I asked it, how can I use Article 1, Section 2 of the Pennsylvania Constitution that says the people have at all times the right to alter, reform, or abolish their government in whatever manner they think proper. And it came back and it produced a process to do it. You need 5% of the registered voters to sign a petition for whatever the text is of the bill. And after that point, it goes to the legislature, and the legislature at that point will perfect the text, and it goes on the ballot. Yeah, I was surprised. I didn't know that. So,
boy, the power of AI is as optimistic as I think terrifying. That's very interesting. I had not thought of that angle before, but I think the difficulty. First of all, I wouldn't tell anybody that came from ChatGPT.
Well, it gives me the legal advice,
Yeah.
it lays out the steps.
Yeah.
There they are.
So there was recently some case law that ChatGPT was creating actually fake cases.
Mhm.
Yeah, I heard
that
that.
courts were, that people were actually including in briefs and citing. So I would not mention that part, but that's a very interesting suggestion. I guess we'd have to look at the precedential support for that. Yeah, I think you're up against the fact that there is no express petition to introduce referendum, so it would be a.
Theoretically, it's there, unless ChatGPT
Well,
lied to me.
I would love to have a candidate run on that issue.
Uh-huh. Geez, I wonder if anybody wants to run for governor down here.
Well.
Yeah, thank you. That's great. That's an interesting point.
You know, and when I send you the text of the constitutional amendment, I'll also include my conversation with ChatGPT. I saved it.
Excellent. Thank you. Very good. Any last comments? Only other thing that I have for you is go out every chance you can to tell as many people as you can that jury nullification is their right, and they should not be dissuaded from using it. And don't put it on your application on your jury.
Sorry.
That's it. All right. Good stuff, man. I learned some things. We have a course of action, and I think I have a new plank for my governor campaign.
I would love to see you run.
All right. Again, on behalf of the Montgomery County Libertarian Committee, I'd like to thank Rob for coming all the way out here from the Pittsburgh area to address us tonight. We do this every month. Next month, we got a goodie. Our guest is Melanie Dante. She's from Swap Behind Bars, SWOP. It's an acronym standing for Sex Workers Outreach Project. The title of Melanie's presentation next month will be Sex Work, a Pennsylvania Perspective. I've heard her speak before. The lady is an activist to help people who are caught between the law and sex work. She calls them viminals. The law calls them criminals, but they're really victims of the law. Very interesting stuff. It'll be held in this very room here at the Lansdale Library. Doors open at 7 p.m. It'll be on August 23rd, fourth Wednesday of the month. Same as all our Liberty Forums. I certainly hope to see you there. And those of you who want to, we have a guest log back there if you sign in. And you can always come to visit us at our regular Montgomery County Libertarian Party business meetings. They're held on the second Tuesday every month. And if you check our website, montcolp.org, you'll find out exactly where it's at. I'm not going to say it because who knows, we may be moving it or whatever. And montcolp.org. Thanks again for coming out. It's a good crowd. Thanks again, Rob, and we'll see you next month.